If you've been injured and someone else is at fault for that injury more than you are, you may be able to make a claim against them. It might be a person or business and their insurance company. Many factors affect whether you are entitled to compensation because of an injury, including the type of accident and the cause of the accident. So that brings up the question, what can I do if I have been injured? It is important that you become familiar with issues related to personal injury claims and your rights. The Iowa State Bar Association has put this video together to provide you with information about issues that you should be aware of when you've been injured. It is not an attempt to provide legal advice, and in fact, the ISBA would encourage you to consult with your attorney regarding your accident so that you can ensure that your rights and interests are protected. To get started, it might be helpful to discuss the types of accidents and causes, because this is what will affect whether you are entitled to compensation. In motor vehicle accidents, fault is determined by traffic regulations and which driver's carelessness contributed most to the accident and injuries. This includes your own conduct, such as failure to use seat belts. Commercial accidents are ones that occur in a business or store. Injuries are compensable only if they are caused by an unsafe condition that the owner knew or should have known of and failed to correct before the accident. When an injury occurs in a home or residence, renters, owners, or residents may be found liable for injuries they caused by negligent maintenance, oversight, or attacks by pets. This does not only apply to homes, but includes farms, apartments, and recreation injuries. One exception to this is that property owners who permit others to use their land without charge for recreational purposes may be completely immune to any claim for unsafe conditions, however flagrant. Accidents or injuries caused by public entities, their employees, or its premises is another category. The negligence of public employees or unsafe conditions will be compensated only in limited circumstances and are subject to stringent notice and claim requirements. State, federal, and local governments are given broad latitude to determine most matters involving public safety, including the design and maintenance of roads, parks, and facilities. In a case of workplace injury, generally these are covered by workers' compensation benefits, which pay for medical expenses, lost wages, and permanent impairments without regard to fault by anyone. If the accident was caused by someone other than the employer or a co-worker, a fault-based claim can be made against that individual, which may include damages for pain and suffering, in addition to the workers' compensation benefits you may receive. What about intentional injuries? Injuries inflicted on purpose by any means generally are not covered by the guilty party's liability insurance, although the responsible party may be personally liable for such harm. There are a multitude of other types of accidents. More complicated rules determine compensation if injuries are caused by dangerous products, the accumulation of ice and snow, faulty professional services, or public utilities. So, as you can see, there are a variety of circumstances or situations where an injury or accident may occur. That takes us back to our original question, what can I do if I have been injured? Insurance policies may cover expenses you incur. Most automobile, homeowners, and commercial liability policies contain medical payments coverage for medical expenses incurred after an accident without regard to fault. This coverage, specifically in auto policies, applies to the insured family members as well as any passengers in the vehicle. Homeowners and commercial insurance policies typically only cover injuries of others and visitors to the property. Accidental injuries are generally covered by health, workers' compensation, or disability policies when they are in place. But remember that if you pursue a claim against another person in an injury case and succeed, the insurance provider will probably require you to repay these benefits to them. If the accidental injury is primarily your own fault, then only health insurance, workers' compensation, or medical payments coverage may apply. If you are involved in an auto accident which is caused by someone who is uninsured or underinsured, your own insurance will provide coverage in these situations. Your entitlement to underinsured motorist coverage depends on the amount of coverage the underinsured driver has and the severity of your injuries. When do you need to retain an attorney to assist you? The Iowa State Bar Association encourages you to consult with your attorney regarding your accident so that you can be sure that your rights and interests are protected. However, if you know for certain that your injury is minor and it will not result in time lost from work or school or substantial medical care, you may want to settle it yourself in small claims court. Keep in mind that when settling with insurance companies, they generally will try to settle inexpensively and on terms favorable to their insured. With this said, if you have a serious injury, it would be wise to consult with an experienced personal injury attorney. Even if you are unsure about the outcome of your injury, it would be wise to consult an attorney. Never provide a statement of any kind about your accident and injury or sign any papers without consulting your attorney. You will be able to discuss your case and the potential fees with your attorney before you commit to any legal expenses. Personal injury attorneys usually handle claims on a contingent fee basis, depending on the type, difficulty, and expense of the case. Contingent fees typically range from 25% to 33% of the ultimate recovery. These arrangements should be in writing, including provisions for out-of-pocket expenses. Any out-of-pocket expenses are typically the responsibility of the client and paid as incurred throughout the case. There are time limits that you have related to resolution of your claim for an injury. The time you have depends on the person or entity that caused your injury. The law requires that you settle your claim, start a lawsuit, or give special notice within a certain amount of time. These laws are called statutes of limitations. Knowing these time limits is important, as they vary from state to state. Many factors go into determining what a claim is worth. Most settlements are based on an estimate of what a jury might consider to be fair and reasonable compensation, given the severity of the injury and its effects on your life. Obviously, you are entitled to medical expense and loss of wages, but other things, such as pain and suffering and loss of enjoyment of life, can also be considered. In some special cases, such as dog bites and flagrant misconduct, additional damages can be authorized. What makes these determinations difficult are the intangible issues that come into play. Severe injuries requiring substantial medical treatment, extended absences from work, and permanent physical or mental impairments may command substantial compensation. On the other hand, juries tend to believe that injuries that cannot be seen or demonstrated objectively are susceptible to exaggeration by the party seeking money damages, and insurance claim personnel know that. All of these factors influence settlements. When it comes to settlement, it is important to have an understanding of the affected person's life before and after the accident. How has the accident or injury changed their life? Were they a productive, healthy young person, and now has that changed? This would warrant a substantial settlement, especially if into the future they have loss of productivity and wages. Remember that if the injured person is found partially at fault for the accident causing the injury, then the amount of damages will be proportionately reduced. Likewise, if there is a substantial chance that the claim may not succeed for any reason, then any pretrial settlement may be reduced. The most important question that people are concerned about is, when will our claim be settled? If the person responsible for your injury has insurance, an insurance adjuster will gather and try to verify the necessary medical treatment records, medical expenses, and wage loss information. If the insurance company makes an offer that you find acceptable, then the claim process is over. Always consult your attorney before agreeing to a settlement. If you find that the settlement that they offer is not acceptable, then you may file a lawsuit. Once you file a lawsuit, each side will conduct discovery to obtain more details and exacting proof about the nature of the claim. Discovery may involve the taking of a party's and witnesses' depositions, asking written questions to each party called interrogatories, and asking a party to produce certain documents or things called a request for production. As the trial date approaches, both the claimant and the insurance company usually take a closer look at the elements of the claim and available evidence to support it, and may try to settle the matter by informal discussion, mediation, or pretrial conferences with the judge. Most personal injury claims settle out of court before trial. Sometimes as many as 9 out of every 10 settle, but it is impossible to know ahead of time if your claim will need a jury trial. From start to finish, it may take anywhere from 18 to 24 months for your suit to get resolved. We hope this video has provided you with some information to help you understand the issues and process surrounding your personal injury case. As you can see, there are many things to be aware of. The ISBA reminds you that you don't need to navigate these issues on your own. Consult with an attorney regarding your accident so that you can be sure that your rights and interests are protected.